immediately exect an amendment to their lease stating the minimum monthly rent. If the parties hereto are unable to agree on the minimum monthly rent for the extended term within said 30 days period, the option notice shall be of no effect, and this lease shall expire at the end of the term. Neither party to this lease shall have the right to have a court or other third party set the minimum monthly rent for rent. Tenant shall pay landlord as rent for the premise the monthly sum of 1,210.30 in advance on the first day of each month during the term of the lease. Rent shall be payable without notice of demand and without the deduction, offset, or abatement to the landlord at the address stated herein for notice, or such other person or such other places as the landlord may designate the tenant in writing. Late fees. A late fee on the sum equal to 10% of the rental payment shall be assessed against the tenant on the 6th day of each month. In the event the regular monthly rent remain update. If you think that the late charge after 6 days is 10%, if you think that that's too much, and then you can request for 5% before the starting the rent. Annual increase. Rent shall be increased on the annual basis, but not more than 3% in any 1 year. That's good. 3 or 5, security deposit. At the time of the signing of this lease, tenant shall pay to landlord a security deposit of $1,500 for the tenant's performance of this lease. Landlord may use the security deposit or any portion thereof if landlord sustain damages resulting from tenant default. Often demand to pay landlord the sum equal to portion of the security deposit applied portion to this paragraph. The tenants shall immediately pay to landlord to requested the sum of as to maintain the security deposit in the sum initially deposited with the landlord. There shall be no requirement that the security deposit held in a trust account or requirement that interest be paid on the security deposit. If all obligations are performed, the security deposit or that portion not required by the landlord shall be returned to tenants within 21 days after the expiration of the term of this lease or after tenant have vacated the premises, whichever is later. Number 6, used. Tenant shall use the premise only for the operation and maintenance of a donut shop, retail sales, and for no other purpose without the landlord prior written consent. Page 37, the bottom line, number 6, use. Tenant shall also not to do, bring or keep anything in or about the premises that will cause a cancellation of any insurance covering the premises or the building in which the premises are located. If the rate of any insurance carried by the landlord increased as a result of tenant use, tenant shall pay landlord without 10 days after written a result of tenant use. Tenant shall pay landlord within the 10 days after written demand from landlord. The amount of any such insurance, tenant shall apply with all laws concerning the premises or tenant use of premises, including without limitation the obligation at tenants sought to alter, maintain, or restore the premises in compliance. The obligation at tenant sought to alter, maintain, or restore the premises in compliance with the laws relating to use, and the occupancy by the tenant during the terms of this lease. Tenant shall not use or permit the use of the premises in any manner that will tend to create waste or mistake, nuisance, or reasonably disturb any other tenants. Tenant hereby accept the premises in their condition in existence as the date that tenant signs this lease, and accept this lease and to all maintenance disclosed hereby. tenant hereby acknowledged that neither the landlord nor the landlord agent, if any other, make any representation of warrant to comment to tenant as to the suitability of the premises for the conduct of tenant's business. 그 밑에 내려가서 신문 좀 갖다 놔. 스포츠 신문 포함해서. 이렇게 이거. Seven. Taxes. 8. Real property tax. Tenant shall pay all real property tax, insurance, and other property expenses during the terms of this lease. B. Personal property tax. Tenant shall pay all tax assessed against their fixture, furnished equipment, and other properties of tenants contained in the premises prior to delinquency. A. Utility. Tenant shall make all arrangements and pay for all water, gas, heat, light, power, telephone, and other utility service supplied to the premises together with any tax thereon and for all connection charges. In this kind of lease, number 7, real property tax should pay to tenants. B. Personal property tax should pay to tenants. Utility should pay to by the tenant. In case this kind of lease, we should call triple for normally lease paper, comma 3 times, comma. This one is all the tax and utility should pay. Sure to remember. 괜찮아? 덥지 않은데요? Page 38, number 9. Maintenance and repair. Except for damage caused by any negligent or intentional act or omission of tenant agent, employees or invitees, landlord at its sole cost and expense shall keep in good condition and repair the foundation of the premises. However, tenant at her sole cost and expense shall keep in good condition and repair the entire roof and the exterior wall of the premises, including without limitation those portions living outside, such as gutter and downspouts. shall clean, remove, lint, wax, and any other materials from the roof of the premises at least 4 times per year. Moreover, tenants at their sole cost and expense shall keep in good order, condition, and repair the premises, and every part thereof, including without limitation. All tenants' personal property, fixture, signs, storefront, plate glass, show window doors, interior walls, interior ceiling, and lighting facility. If tenants fail to perform their obligation as stated herein, landlord may, at the option, but shall not be required to enter the premises and after 5 days prior written notice to tenants, put the same and goods in good condition and repair, cost incurred thereof together with interest thereon at the rate of 10% their omission and 10% annum shall become due and payable as additional rental to landlord together with the next rental payment. 10. Alteration and additions. Tenant shall not, without the landlord prior written consent, make any alteration, improvement, or addition in or about the premises as condition to giving any such consent. Page 39. Page 39. The landlord may require the tenant to remove any such alteration, improvement, or addition as the expiration of the terms, and to restore the premise to their prior condition by giving tenants 30 days written notice prior to the expiration of the terms. Tenants at its sole cost shall restore the premises to their condition designated by landlord before the last day of their terms of the lease. 11. Insurance. Tenant at its sole cost and expense shall maintain during the terms of this lease or all its personal property, improvements and alteration, if anyone and in or above their premises, a standard policy of fire and extended coverage insurance with vandalism and malicious mischief endorsement to the extent of their full replacement value. The proceeds from any such policy shall be used by tenants for the replacement of personal property on the restoration of tenant improvement or alteration. Tenant shall also maintain at household cost and expense liability and property damage insurance with the combined liability limitation of not less than $500,000 and the property damage limit of not less than $100,000 on the premise, insuring against all liability of tenants, and is authorized representative arising out of and in connections with tenants' use or occupancy of their premises. Landlord shall be named as additional insurance insured on the insurance policy. Tenant shall indemnify, and hold landlord harmless from one against any and all claims arising from tenant's use or occupancy of the premises or from the conduct of its business or from any activity, work, or things which may be permitted or suffered by tenants in or about the premises, including but not limited to all damages, cost attorney's fees. Tenant shall hereby assumes all risk, all of damage to property or injury to person in or about the premises from any cause, and tenant hereby waives all claims in respect thereof against landlord. Tenant further hereby agree that landlord shall not be liable for any injury to tenant's business or loss of income thereof from or for damage to used property of tenants, her employees, invitees, customers, or any other tenant further hereby agree that landlord shall not be liable for any injury to tenant's business or loss of the income therefrom, or for damage to any property of tenants, her employees, invitees, customers, or any other person in or about the premise caused by or result from fire, water or rain, from leakage, breakage, or defect of pipes, wires, fixtures, or from any other cause, and from any other resource or places. This limitation shall apply to any injury to the person of tenants or her employees against the contract or invitees. Lastly, landlord shall not be liable to consent for any damage arising from act or negligence of other than tenants of the building in which the premises are located. Okay, some break. You go to the restroom and then to outside break. Hello. How? Yeah. Mm. Number 12, page 39, the bottom, number 12. Destruction or damaging. If during the terms of this lease, the premises are totally or particularly destroyed, rendering the premises partially or totally unusable, and such damaging was caused by a causally covered under the insurance policy required to be maintained hereunder. The landlord shall restore the premises in the substantially the same condition before such, page 40, damaging, provided that the restoration and repair can be complete under existing laws and within 120 days. after the date of damaging. However, such damaging or destruction shall not terminate this lease. If the repairs and restoration cannot be made within the stated by time frame, then within 14 days after parties make such determination, the tenant may terminate this lease by giving notice to landlord, and the lease shall be deemed cancelled as of the day of the damage or destruction. If tenant fail to provide notice, the landlord may, at his own option, terminate this lease or restore the premises within a reasonable time, and the lease shall continue in full force and effect. If the tenant is the insuring party, and if the insurance proceeds are insufficient to effect the repair and the restoration, the landlord shall provide notice to tenants of the additional amount required to effect such repair. Tenants may contribute the amount, but upon failure to do so within 30 days, the landlord may cancel and terminate the lease. If tenants contribute such amount to landlord within 30 days, landlord shall make such repair within a reasonable amount of time, and the lease shall continue in full force and effect. If the damage to the premise is not covered by insurance, then landlord at its option may restore the same provided the damage does not exceed 10% of the replacement cost of the improvement or premises. If the damage exceeds 10% of the replacement cost of the improvement or premises, then landlord may elect not be restored and terminate this lease. Landlord restoration of the premises and provided herein shall not include tenant improvements, trade fixture, equipment, or alteration made by tenants. Restoration of such items shall be the sole responsibility of the tenants. Assignment and subtenant. Tenant shall voluntarily or by operation of law assign, transfer, sublet mortgage, or otherwise transfer or incumbent or any part of tenant's interest in this lease or in the premises without landlord prior written consent. Any attempt shall be void and shall continue a breach of this lease. No assignment or subletting shall discharge the tenant's obligation to pay the rent and perform other obligation required to be performed under this lease. 14. Default. The occupants of any one or more of the following events shall constitute a default and breach of this lease by tenants. A. Failure to pay rent when due. Page 41. B. Abandonment. C. Failure to perform any provision of this lease. If such failure is not occurred within 21 days, after written notice thereof has been given to tenants by landlord. If the default cannot be occurred within 21 days, then there shall be no default as long as tenants commence to other within the time period and diligently prosecute the same to completion. D. General assignment for the benefit of condition. Filing of bankruptcy petition, including reconciliation under bankruptcy laws, appointment of a trustee, of receiver for tenants asset in the premises or tenant's interest in the lease, attachment, execution, or any judicial seizure of tenant's asset at the premises or other interest in the lease. Landlord premises remedies. Landlord shall have the following remedies in the event tenants default under this lease. These are not inclusive but are accumulate and in addition to any other remedy provided by law. A. Continue lease in full force and effect as long as landlord does not terminate tenant possession, and the landlord shall have a right to collect rent when due. B. Enter premises will let them or any part of them to third parties for tenant's account. Tenant shall be liable to their landlord for all costs incurred by the landlord in relating the premises, including but not limited to broker's commission, remodeling of the premises required by relating. Tenants shall continue to pay landlord the rent due under this lease. Less the rent landlord receives from any relating, in no event shall tenant be entitled to any excess rent received by the landlord. Landlord can be his option terminate tenant's right to possession of the premises at any time. Terminate the lease by providing tenant's written notice of termination. 16. Holding over. If the tenant with the landlord permission remain in the possession of the premises after expiration or termination of the terms of this lease, such possession shall be deemed to be month-to-month tenancy. Any holding over without permission shall not substitute or renewal of the lease. This meaning for the month-to-month tenancy, meaning every month, one time per paid rent. Any rent, everybody, almost 99% month-to-month tenant. Binding or 42 page. Binding on successors and assigns. All of the terms of this lease shall be binding on and shall inquiry to the benefit of the parties. Their hearers, personal representative, successor, and assignment. 18. Notice. Any notice of any kind shall be the writing and served either personally or sent by registered and certified United States mail postage prepaid at the address at both below. Landlord and tenant, both party, name and address. 19. Landlord inspection. Landlord and his agent shall have the right to be entered premises at reasonable time for the purpose of inspecting the time for any purpose, and as the landlord may deem necessary or desirable. 20. Choice of law. The lease shall be governed by the laws of the state of California. 21. Attorney fee. If either party commence on action against the other parties arising out of or in connection with the lease, the prevailing party shall be entirely entitled to have and recover from the losing party reasonable attorney fee and cost of suit. Losing party meaning for the losing in case they should pay attorney fee also. 22. Prior agreements. This lease contains all agreements of their parties with respect to any matter mentioned herein. No prior agreement or understanding pertaining to any such matter shall be effect. This lease may be modified only by writing and signed by the parties in interest at the time of such modifying. 23rd. Severability. The unenforceability, invalidity, or illegality of any provision of this lease shall not render the other provisions hereof unenforceable, invalid, or illegal. Page 43. The parties have executed this lease or the date the first above written, landlord name, date,